at the Supreme Court, there's a lot going on. But what really struck me was I didn't know the Supreme Court could do anything unanimously. So when I got the headline and it said unanimous vote by Supreme Court, I went, holy cow, what was it? And I didn't quite understand what it was. And so then, of course, the next thing is they started questioning whether Ted Cruz is a U.S. citizen and can serve as president. And the third thing that happened in the short order was Judge Garland not being accepted or even interviewed to be a nominee for the Supreme Court. To those three questions, I had asked Egberto to moderate so we can move this along and ask you guys to give us whatever in layman's term, please. None of the whereas is legally stuff. So, Egberto.
First of all, I'm Egberto Willis, the radio host at Politics and Right at KPFT. Thursdays at 3 p.m. Listen, call in, and actually be a part of it. First of all, I want to say that I'm extremely happy to see everybody out here. It's amazing that everybody started to be a part of the body politic. I think that is something that we've been lacking for a long time. I know Diane, the ROADWomen, that has never been a problem. Also, we also know that Diane came here and she asked me to do this, but interestingly enough, she actually started the moderating. So, you think I really need to stay, or is it okay with you? Okay. Anyhow, Diane started, the first part of that we wanted to discuss was the Supreme Court case, which was actually titled Evenwell versus Abbott, and that entailed the one person, one vote rule. And what I want to ask Professor, first of all, is exactly from a constitutional point of view, what is the effect of the ruling?
Well, it's not so much from a constitutional point of view as much as really a political point of view. If you exclude, the question here was simply that when you're figuring out the apportionment of districts, how many people per, in this case it was state senate, the account, all the people living in the district are only the eligible voters. You count all the eligible voters, you eliminate, first of all, illegal aliens, you eliminate children, you eliminate people who just moved there, and so forth. The general feeling is that the decision will help Democrats because it's likely to, affect districts that are in urban areas where they're more likely to be these people. Obviously, children can be any place, but the people who aren't citizens are more likely to be in an urban district than a rural one. The suit is a strange suit. We're used to suits being brought under the Voting Rights Act by liberals or by minority groups trying to undo unfavorable districting by the white majority. In this case, Texas, like every state in the Union, did its districting on the basis of all the people in the district. This suit was brought by two voters, nominally. One in a Senate District 1, which is up near Texarkana. The other, Senate District 4, which are the counties east of Houston going to the Louisiana border. Both conservative districts, and in both cases, these people are saying, no, this thing is unfair because it counted people who can't vote. The implication being they'd do better if the thing were changed. There's no states in the Union that do it any way different from Texas. There's some little minor glitches, but basically not. So this was not a, as if there's a big issue involved here. Nobody was doing it the other way. They brought the suit, it went to a 3-judge district court, which is the procedure used mostly in voting cases now. And when you lose from there, you go directly to the Supreme Court. They lost before the 3-judge district court, which poured them out. Just said, doesn't state a federal question. So then they went up to the United States Supreme Court. Given that the case law was pretty much totally against it, that if you wanted to look at the Constitution with that clear Section 2 of the 14th Amendment seems to make a reference to total people in the district, so that's supportive of them. Everything was against them. The assumption in a case like that is the Supreme Court usually doesn't hear the case and simply dismisses the appeal, saying does not raise a substantial federal question. They could have done that. Strange things they didn't. Instead, they set it down for oral argument. They unanimously affirmed, and the Chief Justice, who could have assigned it to himself or to Justice Alito or Justice Thomas or Kennedy, assigned it to Justice Ginsburg. And we got out of this thing a very strong opinion from Justice Ginsburg, affirming the notion of one person, one vote. Over concurrences, which means you got the right result, but for the wrong reasons, by Alito and Thomas, who don't like the one person, one vote rule, but didn't go against it quite. So the effect of this is more, as I say, the actual result is unremarkable, but the way it got there is, I think, fairly remarkable. Why the Chief Justice assigned it to Justice Ginsburg, I have no idea. Why the court decided to have full oral argument and a full brief, a fully written opinion, instead of just affirming it without opinion, I have no idea. But the effect was that they seemed to care about this rule. And this rule, as I say, I think is on the whole a very good rule. And I think from the point of view of the Democratic Party, it's a good result, because I say it will favor, as it already does, urban districts over rural districts. So that's kind of important. One little cute thing that I thought about in reading it, there's a whole question of where you should count people who are in jail, in prisons. In most states, they are counted in the county where they're imprisoned, which is usually a rural county. These people are usually non-white and from urban areas, and they're moving up the total number of residents in the rural area, which tends to favor these conservative rural areas over the places where these people are from. This thing doesn't change that. There's a footnote in which Justice Ginsburg said there are states who have this other rule that says, no, you don't count prisoners. You can count them where they used to live, where their domicile is. You can also do that with military people, and with college students you have that question. Sometimes college students take over a county. You know, if you have a state college in a place, this happened in Prairie View. You know, had a lot of people, and they all registered out there, and suddenly Waller County had this big black population that it wasn't very happy about, and tried to keep them out. But it doesn't seem to have changed that. I thought of it when I read it. Is that going to change that? That footnote suggests that we might allow that, because there's some real arguments why that should be. But as I say, in the whole, that's what, to me, that's what this opinion means.
But isn't it true then that what that means is that precedent hasn't been set? So we're going to have this going to the Supreme Court over and over again.
No, I think precedent has been set. It's been set, you know, it's been set to the extent of saying no. There's a question of whether they could do it the other way. That was left. That was not resolved. Theoretically, they still could go the other way. Because Texas came in and said, we can do it either way. Others were not happy with that. But the fact that this strong opinion suggests that this is the right way to do it, and suggests that it's connected with the very important Supreme Court precedent of Reynolds versus Sims, which is the one person, one vote rule, I think will make it hard. I mean, even before we figure a fifth liberal vote on the court, I think even with this court, it is hard to go the other way. Can't be sure.
Now, Chad, what's the implication of this specifically within the different districts in Texas, and does it really matter at all?
Well, it's hugely consequential here in Texas. So let me back up and talk a little bit about what has happened in redistricting in Texas since 2011 and how this case plays into it. First off, Texas comes out after the Evanwell decision, this recent Supreme Court case, looking like it's doing the right thing by its voters. So I want to disabuse you of that notion immediately. Texas sat down in 2011 and passed what is probably the most racially discriminatory redistricting maps in the nation. And they are still under review by courts and have been found by 6 federal judges in one respect or the other to violate the Constitution because they intentionally discriminated against Black and Hispanic citizens here in Texas. So the same legislature that made the decision to draw those maps is the same legislature that made the decision to use total population figures, the figures of counting the number of persons in the district and drawing the districts on that basis. Now, it's a little bit of a necessity on their part as well because we don't have good data to count the number of people who are so-called eligible voters. And in fact, during the George W. Bush administration, there was a very active effort by members of his Justice Department and his White House counsel team to eliminate the Census Bureau's collection of that data because it was being used by litigation attorneys like me to prove that states had intentionally discriminated against citizens. So Texas didn't have much of a choice in 2011. But what the state what they tried to do in this case was sort of have their cake and eat it too. So when these plaintiffs came forward, they were represented and supported by the same folks who handled the case that undermines the Voting Rights Act. That I'm sure some of you have heard. I got to hold my mouth good. Okay. So the same folks that were behind undermining a key part of the Voting Rights Act in a case called Shelby County two terms ago brought this case. And they brought it against, in my view, what they thought was going to be a friendly defendant. They thought Texas would come in and say, you know, we did it this population way because that's the way it's always been done, but you know, maybe you're right. Well, it turns out that Texas put up a moderately vigorous defense to the case. And when it got to the U.S. Supreme Court, a lot of us, as the professor I agree with indicates, a lot of us were surprised that the Supreme Court set it down for argument. I represented a group of Texas senators, in fact, all of the Democratic senators in Texas. And we filed a brief in that Evanwell case, and I was there in the Supreme Court chamber during the argument. One of the things that I immediately noted is the conservative members of the court almost, and of course I'm reading the tea leaves here, but it almost seemed like they thought the case was a joke themselves. In fact, there's been some commentary by some folks that Justice Scalia's death might have played some role in the outcome in this case. And I don't get that sense. In fact, I believe that Justice Scalia was telling the court it would have been 9-0. And the result it went to. But here's the effect it has. There was an important gap left in defense. The professor mentioned that Texas had come in and said, yes, we can do it this way, and it ought to be constitutional to count the whole number of persons. But you should also say that we could have done it other ways. We could have picked just the registered voters, or we could have just picked people who are citizens in a voting age. And the Department of Justice intervened in the case and said, no, you shouldn't do that. In fact, you should say that it has to be the whole number of persons. And the court punted on that question. So here's what I think in Texas. I think that when we get around to redistricting here in 3 or 4 short years, there's going to be a movement by at least some members in the House and the Senate in Texas to say, well, look, the Supreme Court left an opportunity here. Let's draw these districts using citizen voting age population, or even worse, from my perspective, let's use the registered voter population, which in Texas, after over a century of intentional discrimination in voter registration, has abysmally low voter registration figures. So using that number would further what has been, unfortunately, the state's historical interest, the legislature's historical interest, to undermine the votes of African Americans and Hispanics. So what does this mean? This is a lot of detail. Let me talk to you about your districts, for example. So. There's a lot of talk that this case was really about undocumented immigrants, people who were in the country.
Let's try that. We can just shout as well.
We'll shout if necessary.
We can hear you.
So there was a lot of commentary that this case was about undocumented immigrants and how they were somehow getting counted and included in the process. And there's no question there's a substantial undocumented population in Texas and other states, California in particular, but That's not really what this case was about. What this case was about was young people. And in Texas, the young population is overwhelmingly higher proportion African American and Hispanic than it is Anglo. So if you want to draw districts that are controlled by the Anglo population, then what you do is you try to figure out how not to count individuals who are black and Hispanic. So the way you do that is by saying, well, we're not going to count children and allocating the district any longer. And in Texas, because the population growth rate is overwhelmingly Hispanic and black, what that means is you're going to end up counting a lot more white people disproportionate to the white proportion of the total population. And incidentally, this isn't a new debate. This came up during the federal debate in the 1787 convention when the federal Constitution was passed. And in that document, it said that you're going to count a whole number of persons, and those whole number of persons will be allocated to the states. Now, it's worthy of note, the reason they use the term whole number of persons is because in the rest of the document, it talks about how certain folks are 3/5 of persons. So those persons weren't going to count.
But bear in mind that those 3/5 still increased. That was a tremendous bonus to the slave states because they got 3/5 of a seat for every slave they had. The slaves couldn't vote. And so the interesting thing, I'm in complete agreement, but the interesting thing is that Justice Ginsburg pointed to that and said that's an argument against these plaintiffs. Because even if they only counted as 3/5, they still counted the slaves. Sure, they gave a discount. The discount didn't disfavor the slaves. It disfavored the slaveholders. The 3/5 thing was a bonus to the slaveholders. It was not an insult. The slaves were insulted enough. But this wasn't an insult to the slaves. If they'd made it 5/5, the South would have had a bigger majority in Congress. You see? But the main point was that Justice Ginsburg said, this shows these people were virtually represented. That is, even if you can't vote, the person sitting there represents you. You're one of his constituents. She makes a big point about that. And I think that might help in future litigation.
I think there's quite a bit of things in Justice Ginsburg's opinion that will help. She also talks about the importance of representation, not just voting rights. That, you know, you're entitled, even if you're a child, you're entitled to have representation on the hospital district or your school board and that sort of thing. One last thing I want to say about the districts and how it will affect here in Texas. So in addition to discounting the children population and therefore the racial skewing that results in, it also has an urban versus rural dynamic. So we're the state to decide, and the Supreme Court to bless it in a few years, to draw the districts on a citizen voting age or voter registration standpoint. And what you'll see is a lot of districts that are in urban areas will get drawn out into rural areas. And that is the favorite tool of Republican redistrictors to create districts that are discriminatory. They take a large block of largely Anglo, older population in rural areas, and they bring what we call fingers into the city. And if you want to look at an excellent example of it, go to the Texas Redistricting Viewer right now, pull up any city in Texas, and you'll see rural districts that bring in fingers into the main population, essentially burying black and Hispanic votes in a sea of white rural votes. So we don't have to count as many of those people in the urban area, because that's also, it just so happens where the younger people are. Urban areas skew younger than rural areas. So if we don't have to count those people, then what we end up with is more districts controlled by the white population, and to Republicans, at least under the current state of affairs, that means more districts that elect Republican candidates. So that's what's at play in this case. And, you know, I hate to put it any other way, but we dodged the bullet with how it came out this time. I think there's some markers laid down by Justice Ginsburg that should help in the future, but the issue's not going away.
The Koch brothers are already working on that plan. Really, not kidding. But anyhow, before we go on to the next subject really quickly, are there any questions that anybody wants to ask? Yes, ma'am.
I've been asked on several surveys how I feel about automatic voter registration at 18 years old for every single person in the United States. And I really didn't know an answer to that, but your presentation leads me to conclude that if we automatically register every 18-year-old on their 18th birthday, just like giving them a Social Security card on their 16th birthday like I got, that would render this whole argument moot, and it would be beneficial for the population. So I just wanted to make that comment.
Well, sure, I certainly agree with the notion that there should be automatic registration. Most countries do that. A lot of people talk about Mexico for some reason. People on the right like to say, well, look, even in Mexico, you have to have an ID to vote. But what they don't tell you is that Mexico issues you that ID free of charge with your photo on it at 18, and you're automatically registered. But registration in the United States, I can't sugarcoat this. Registration in the United States is left over from Jim Crow. It was created in the late 1800s in the South as a way to disenfranchise blacks. And there's really no reason for it at all. So if I was given the wand that could change the policy, we would get rid of registration altogether, which doesn't mean anybody can show up to vote. There are other ways to deal with that. But your point's well taken. I think the professor may have.
Yeah, they have the motor voter law, where when you renew your driver's license, they're supposed to say to you, would you like to register? And this is very useful. There's a lawsuit going on right now. I think it's in court. I'm not positive. Because apparently if you try to register to renew your license online, which is very popular, you get sent to another link and then they tell you have to mail something in and they don't put an address on there. They do a couple of things like that. And this lawsuit is saying that's a violation of the Voting Rights Act. And it sure looks as if it's pretty hard to explain this thing on any other basis, but simply trying to undermine the motor voter law, which is a good way of compromising what we're trying to do. Another point that I know, and you would know much better than I, we all talk about how low the voter percentage of voting, of people voting in America compared with other countries. My understanding is the percentage of registered voters is fairly high. And the reason people don't vote is they're not registered. And making it easier for them to register raises the number of people who vote. That's why the motor voter law was put in. And there are other things, of course, that can be done, but they're generally left to the states, and the states can undermine them, especially now that we don't have Section 5 of the Voting Rights Act in effect. Section 4.
Okay, any other quick questions before we move on? Okay, the next subject that we're going to talk about is whether El Señor Ted Cruz is a natural-born citizen. I'm a citizen of the United States. I'm originally from Central America, from Panama. I always wondered about that. I even wondered about that when John McCain was running, because it turns out that John McCain was born in exactly the same hospital that I was born in. It's called Cocosolo in Panama. Okay?
We own the Canal Zone. We
No,
didn't own it.
the United States never owned the Panama Canal Zone, and it was leased on a contract for 99 years, so therefore it was in U.S. soil.
It's kind of interesting, because the court's made a distinction between one
Exactly. So we have to, I want to ask a question specifically this way. We want to know if Ted Cruz is a natural-born citizen. We know that he was born in Canada.
Right.
We also know that his father was a Cubano from Cuba.
Right.
We also know that our president was born in Hawaii. Of course, a lot of folks on the right believe that Hawaii is another country. You know? No, actually, that's not the reason. Many didn't know that Hawaii was a different country. They thought it was a different country. In fact, I wrote a blog that mentioned that he was born in Canada and that the president was born in Hawaii. And one of the ladies told me that who answered the blog said, but Canada is one of our states. Kidding? Nope. So my question to you, constitutionally speaking, is Ted Cruz a real American, a natural-born American citizen?
And I've read a bunch of stuff on this. It's not an issue that I'm taking very seriously. I think if it got into court, I think he'd win. I think he ought to win. I'm very happy if he wouldn't, but I don't think, I really, I'd rather see Trump as the nominee. But, this has nothing to do with the constitutional law. I think he probably should win, but the real problem is the Constitution says natural-born citizens. That's the wording of it. We have an immigration law, a naturalization law, which has different procedures and pretty clearly makes him a citizen from birth. because his mother became a citizen at a certain point, and that's okay. Excuse me. The argument is, though, that that immigration provision, that naturalization provision, doesn't govern the Constitution, because that's about when you become an American citizen, but the Constitution says natural born citizen, and we don't know. There is no case law. There's been a whole bunch of things. You know, you also had George Romney, Mitt Romney's father, when he was running, was born in Mexico to American citizens, but they were Mormons who had left the United States and moved down to Mexico and started a colony down there. And there were people saying they in effect gave up their citizenship. Nobody ever found out because he didn't get the nomination. You know, things like that. I'll tell you the really silliest thing. There's a guy who teaches at UT Austin named Sandy Levinson. He's a very bright guy. Sandy is really smart. His first appearance in court, when he did a pro bono case, got him in the United States Supreme Court, his first court appearance, and he won. He's very smart, but he loves to tweak everybody's nose. So for years he was talking about how the liberals should be teaching the Second Amendment when nobody else taught it. That was before the Republicans resurrected it. Things like this. Well, he wrote an article called, "Was George Washington Unconstitutional?" Was George Washington unconstitutional? His reasoning was this. The Constitution says must be a natural born citizen or a citizen of the United States at the time of the enactment of the Constitution. The Constitution says it takes effect when 9 states ratify it. Virginia was not one of those 9 states. It was a later state that did it. So at the moment that the Constitution took effect, Virginia was not part of the United States because it hadn't yet ratified the Constitution. So Sandy said, so on that conclusion, George Washington was ineligible to be president of the United States. Yeah, that's about it. I view the whole thing as very silly. You know, it's great politically, but I don't take it too seriously.
In that case, Arnold Schwarzenegger should actually run for president then.
Well, they wanted to change the Constitution.
I know, but it seems like they don't have to based on that.
Well, I agree, it's all very silly. I think Schwarzenegger is different because I don't think either of his parents were American citizens, but I'm not sure of that. I have a similar opinion. I think if this ever gets decided by the court, it will be determined that Ted Cruz is eligible. Here's what I would add to the discussion, though, for next time you're in the water cooler discussing this subject with friends. The conservative point of view of the Constitution should lead a fair-minded jurist to conclude that he is not an eligible person to run for president. And it's only because I have a more flexible view of the Constitution that I conclude he ought to be eligible. But there's been quite a bit of scholarship on this, and at the time the federal Constitution was drafted in 1787, the English common law, which was incorporated in this provision, clearly found that natural-born citizen meant born in the homeland, not even born within a territory or in a military installation. You had to be born in the homeland, and there's a lot of publishing on that prior to the convention. So the conservatives have tried to ignore that. Conservative academia that have tried to get around this problem have found some later statutes passed in England that say, well, no, you can be born in other places and still be a citizen of the crown. The problem with that is that those are statutes, which means they're not part of the common law, and they also came after the adoption of the federal Constitution. So I think if you're being intellectually honest about the subject, and you have a strict constructionist point of view to the Constitution, you'd have to conclude that Ted Cruz is ineligible to be president. I don't share that view, and I don't think that ought to be how we treat our federal Constitution. So as much as I don't want to see Ted Cruz as president, I think that him being eligible ought to be the conclusion. But there's another issue that's involved in this, and that's standing to sue. And I think that question, were it to get answered this election cycle, could be immensely consequential in a number of other areas, irrespective of Ted Cruz's eligibility. So typically a voter or a citizen can't sue over an infirmity with another candidate's campaign. So, and this is true in state elections here in Texas. If your opposing candidate, or the Republican candidate, for example, has something wrong with their ballot application, or maybe they don't live in the community, or maybe they're not a lawyer and they need to be the judge they want to run for, then Joe voter can't, or Jane voter can't sue over that. So what most states, the federal courts have decided is an opposing candidate can, and then sometimes the state or municipality or school board or whatever running, they can also bring a challenge after the election. So I think the courts will ultimately decide, and they already are, they've got cases over Ted Cruz's eligibility all over the country. Most of them are getting dismissed on the grounds that the plaintiff doesn't have standing. It'll be interesting if Ted Cruz becomes the nominee, whether or not Bernie Sanders or Hillary Clinton brings a claim. Because I think it's crystal clear that the Democratic nominee could bring the claim, an independent who's going to face them on the ballot, maybe a Libertarian candidate, a Green Party candidate, somebody who has ballot access against the Republican nominee could bring such a claim. And I think it'll get resolved. I think the Supreme Court will feel obligated to resolve it. And so that to me is the interesting part of it. But that's sort of inside baseball for us lawyers.
I think somebody's itching for a question.
I'm curious, can Donald Trump sue?
Well,
Trump could sue now. The question is to whether or not his claim is ripe any longer. So in addition to having to have standing, you got to file your lawsuit in time, okay? And a lot of it, so it's to be done on a state-by-state basis. You have to file this in a state where they have not yet voted in the primary, where Ted Cruz's name would appear on the ballot. But I think it depends on the state. In Texas, there's a very good chance that the court would say that case wasn't right yet. I mean, it's either moot or it's right. I mean, there is a case in New Jersey, but I don't think it's Trump that filed it. But I could be mistaken about that. There was a case here in Houston, filed by a lawyer here in Houston. It's been dismissed for lack of standing. What courts really don't want in these things. And so in a lot of ways, and it's more than just Ted Cruz, they erect ways of saying, well, you can't be too late on your claim, but you also can't be too early. And by the way, you got to wear the right dress and the right stockings when you come into the case. And it's so many sets of rules that finding the perfect plaintiff and getting it all done just right is nearly impossible. And I suspect that might be how Ted Cruz's situation works.
Dunn?
I'm putting something up here and saying, get to the next topic.
Okay, excellent. Quickly?
Yeah. Did Ted Cruz's mother vitiate her citizenship in America by being on the voting rolls in Canada?
Well, that would depend upon her individual state laws. And so
What was the question?
it was whether or not Ted Cruz's mother, by registering to vote in Canada, relinquished her U.S. citizenship and therefore made her not a U.S. citizen, and therefore where he was born isn't consequential because he doesn't have American parents. And so the answer to your question is, I don't know. We'd have to look at the individual state that she domiciled. But that does remind me of another point that was raised earlier with President Obama. The whole, well, except under the time, place, and manner clause. I think that's a complicated issue.
I won't argue that.
Okay. But here's one thing I was going to add about President Obama. We had this giant debate. Donald Trump led the charge, asking whether President Obama was born in Hawaii. And nobody has ever disputed, though, that he was born to an American mother. And so where he was born in Hawaii wasn't consequential. And so again, if you're conservative and you're keeping a consistent point of view, then Ted Cruz ought to be ineligible. Because yes, he was born to an American parent, just like President Obama, but he was also born out of the country, just like you think incorrectly President Obama was.
Okay, we're going to move to the other subject, and then after this, we can ask them individually. Okay? All right, now we're going to talk about Judge Garland. As we all know, the president has nominated somebody for the Supreme Court. Actually, I don't know if it's too much of most of our likings, given that he's a rather centrist person. That said, tell me, first of all, has this ever occurred before that we've nominated somebody in and during an election year?
Yeah, it's been done a whole bunch of times, but in a lot of different circumstances. Jerry Bernberg put together a list, which I have someplace on my cell phone, but I don't have it handy. But there were a number of things, and a number of times somebody was nominated in year 7, but the vote didn't take place until year 8, and so forth. And some have been fairly recent. We've also had some weird things. In 1876, there was a big dispute over the election. The 1876 election was a lot like 2000, even involving questions about Florida law and Florida votes. In the end, a deal was made between the Democrats who were racists and pro-Southern, This was during Reconstruction. And the Republicans were in favor of Reconstruction, but are kind of losing their enthusiasm. And the deal was, we'll vote for, a commission was set up because there was a tie, things like that. We'll let the Republican become president if you remove the troops from the South. They removed the troops from the South, which was the end of Reconstruction, meant the blacks were thrown back into what became Jim Crow. You know, it was a terribly, it was really a disgraceful deal all around. And the guy who became president was Rutherford B. Hayes. He then didn't get the Republican nomination 4 years later in 1880. But in November or December, in October or November or December, someplace around there, there was a vacancy on the Supreme Court. He filled it, even though he'd been defeated even in his own party. And 3 months later, and the vote had already taken place, he'd already been replaced, and the new president was coming in those days on March 4th. That's the clearest example I can think of, but there were many. But, you know, we also have to face the fact that Joe Biden said it shouldn't be done, Barack Obama said it shouldn't be done. This thing is simply plain politics on both sides. There's nothing in the Constitution about it. I can see a pretty good argument for a lame duck president not appointing somebody who may be on the court for 30 years. I can also see the opposite argument very well. And the answer to me is very simple. This thing is a disaster for the Republicans. It doesn't matter what they'll do. The worst case scenario would be the election takes place, the Democrats win, and then they quickly vote up Judge Garland so that the new president can't make a more liberal appointment. If President Obama doesn't want it, President Obama presumably picked him because he wanted it, because he had considered him in the past. But if he wants to, he can withdraw the nomination at any time. In fact, even after he nominates him, even after the Senate confirms him, if he doesn't sign the commission, it doesn't take effect. So he could theoretically kibosh that thing. It's not likely to happen. But in the meantime, if they sit around and do nothing, which is what it looks like they're going to do, that certainly doesn't, it certainly helps the Democratic Party. And I think that's the answer. In my mind, as I say, I don't see it as a constitutional issue. I don't see it as an ethical issue, because I see the ethical issue in both directions, depending on whether I got the White House or they got the White House, and who has the Senate. I have a question.
And I'm going to pass it to you, Chad. First of all, can the president recess appoint Judge Garland into the Supreme Court?
So I was going to bring up recess appointments, because you can't talk about this issue without talking about how recess appointments have turned out. The answer is he has the authority to do so, but it won't happen. And it won't happen because the Senate has decided not to adjourn in time and therefore create an appointment during a recess opportunity. And so this came up during the George W. Bush administration. Both parties do it. I mean, when people ask me about this issue, Judge Garland and recess appointments, and I mean, look, let's be honest. If this were George W. Bush in the last term of his presidency and Justice Ginsburg had died and he had put forth a nominee, the people who would be taking their positions would be the exact opposite people who are expressing that view today.
But they did.
And so, right, and they did. And so I try to be balanced about my opinions. I understand the Republican point of view, as the professor states. I understand the Democratic point of view in this situation. To me, I think it's more helpful to have a discussion about this in terms of the longevity of the federal Constitution. There's a serious problem going on with the operation of the federal Constitution right now. And the recess appointment was the escape valve. The Senate always had the ability to filibuster, not necessarily filibuster, that's a more recent development, but they always had the ability to sit on it and not vote on a nomination. There was much more comedy in the prior century, 2 centuries ago, in the Senate where that wouldn't happen. But as that started to happen, then you started seeing recess appointments, and now you're seeing it where the Senate won't even adjourn to create a recess, so there is a recess appointment, and it's a real problem. I mean, we see it, I think we're going to see it in the ruling of the Supreme Court in the immigration case, unless the Chief and Justice Ginsburg and others can work out some kind of deal. We're going to see divided opinions on important things, but it's not just the court that's an issue. We have federal agencies. There are heads of the Department of Homeland Security right now, a critical agency I think everybody in the nation would agree on, that haven't been replaced and confirmed, and the Senate won't go into recess, the President doesn't have the ability to do recess appointments. So, you know, the best idea, the last thing I'll say on this, the best idea I've heard about dealing with this issue is some kind of agreement needs to be reached between the political parties, probably in the form of a Senate rule, that says starting 6 years from now, these are going to be our rules on appointments. And here's how long they get an automatic vote in committee. After X number of days, you get an automatic vote on the Senate floor. You can't filibuster, you can, but you break it with cloture, this number of rules, etc. That lays down how this works. And put the deadline for that rule, the trigger for that rule to take place, far enough down the line where none of the parties know who's going to benefit or be damaged by it. And I think we got to seriously start thinking about those kinds of solutions, not just for this problem, but other problems in the current operation of the Constitution.
But that is not constitutional, right? In other words, unless you have a constitutional amendment that actually codifies that, that's just a gentleman's agreement, just like filibuster is a gentleman's agreement.
Well, I'm not sure it's a general person's agreement. The Constitution itself says that the House and the Senate can set their own rules. And so if the House and Senate decide to set this rule, then sure, a future House or Senate can undermine that rule. But, you know, there will be a lot of, you can put procedural place markers in the rule to prevent that from happening. And sure, as Ben Franklin said, we've got a republic if we can keep it. Everything we do as Americans counts on our kids and their kids being rational and running the country. And if at some point we lose that ability, and some people think we might be there now, then we're going to need a new federal constitution, which isn't always pretty to put together.
Okay, that's the end of the panel.